have to hope there is. All righty. Chapter 11. Okay, so in the last chapter, we talked about the contracts between the seller and the sponsored broker, the buyer and the sponsored broker, so us and our clients, right? Chapter 11 deals with contract law, okay, between the contract between the buyer and the seller. So these would be the contracts that we're going to put together for people who are looking to buy or sell real estate. Got it? Okay, so thing drives me crazy. So there's some terminology you got to know about contracts. Page 189, let's start first, second paragraph down. A contract, highlight, a contract is a voluntary agreement or promise between legally competent parties supported by legal consideration to perform or refrain from performing some legal act. Okay? Drop down to express and implied contracts. Okay, so stick with me, don't highlight too far ahead because it might be stopped. Depending upon how a contract is created, it is either express or implied. An express contract, also called an express agreement, exists when the parties state the terms and show their intentions in words. Stop there. Skip to the last sentence of that paragraph. In an implied contract, the agreement of the parties is demonstrated by their acts and conduct. Okay? So, an express contract is one that is either written or oral. Okay? You can have express contract. Angie, I want to buy your car for $500. All right, I'll sell you my car for $500. That's an oral contract, right? An express contract, it's an oral express contract. Then there's the written express contract. I want to buy your property. I want to sell you my property. Okay? So both oral and written are considered expressed. An implied contract is when our friend here, Angel, his favorite restaurant, Red Lobster. So he goes to Red Lobster and he says, give me the biggest lobster you got. Do they make you sign a form? No. What do? They boil up that bad boy and they bring it to you. Why? Because you have an implied contract. By your actions, you walked into the restaurant and ordered the food that you're going to pay for the food. Got it? So you didn't up front say, hey, I'm here to pay for the food, right? So you did not have an oral. You did not have a written agreement. It was implied by your actions. Got it? All right. Turn the page. Unilateral, bilateral. What does uni mean?
One.
One. Exactly right. It's like uno, but it's one. Same thing. Uni. So a unilateral contract is a contract where one party is obligated to perform. Okay? Either you have a dog.
Yeah, I do. Yeah.
Okay, what's your dog's name?
Rudy.
Rudy. Mm-hmm. So if you went home tonight and Rudy has escaped from the house, would you be sad? Some people say no, that's why I asked.
No.
So you'd be sad, right? So she would put up posters around town. Bring Rudy home, give you $100. Okay? So Anita's walking down the street and she finds a dog, she brings it to your house. It's not Rudy. Do you have to pay the $100?
No.
Maria's walking down the street, she finds a dog, she brings it to your house. It's Rudy. You gotta pay her the $100?
I should.
No. You got it.
Okay.
Because you put a unilateral contract out there that said, if you bring my dog home, I will give you $100. Now, the reason it's unilateral is because neither Anita nor Maria agreed up front to go look for the dog. They were not contracted to go look for the dog, but they fulfilled the contract that you put out there, so you owe them the money. With me? A bilateral contract, what does bi mean? Two or more. All parties to the contract are obligated to perform. So a real estate sales contract between a buyer and a seller is a bilateral contract. Okay? You want to buy, she wants to sell. There's two people involved in the agreement. At a minimum, two people involved in the agreement. All right? Now, next, executed versus executory. If you walk down the hall and you talk to some realtors and you said, hey, what do you call it when the seller accepts the offer, when she signs the offer? Most of them will say, I have a fully executed agreement. And they're all wrong. They don't have a fully executed agreement. An executed agreement, the word executed means performed as agreed. In real estate, when do we have a executed contract?
Closing.
Closing. So when it's closed, it is executed. At the point that you sign it and accept the offer, it becomes a contract. It is called executory. It is in process until it closes, right? So you sign it, it becomes executory until it is executed at closing. With me?
Mm-hmm.
I'm going to try to trip you up on those. Just remember, ED, it's done. Got it?
Mm-hmm.
Now, every contract is either valid, void, voidable, or valid but unenforceable. I'm going to walk through each of these so you understand what they mean in a minute. For now, I need you to go back to the page before. And where you highlighted, I had you skip. I now want you to highlight what's between them. So under express and implied contracts, highlight, under the statute of frauds, certain types of contracts, including those for the sale of real property, must be in writing to be enforceable in a court of law. Enforceable means the parties may be forced to comply with the contract's terms and conditions. Okay, so in the last chapter, we said that exclusive brokerage agreements, right, have to be in writing to be enforceable. In this chapter, we're expanding that definition to say all contracts in real estate must be in writing to be enforceable in a court of law. So that includes the exclusive buyer-broker agreements, the representation agreements. It includes all sales contracts, and includes most leases. So there's one exception to the statute of frauds, and it is a lease term of less than 1 year. So let's say he has a building, and I say I want to lease the place for 6 months. He says it's $1,000 a month. I hand you $1,000. Technically, we have an oral lease that is enforceable because it's for less than a year. If I said I want to live here a year, he would have to put it in writing for him to be able to take me to court to enforce it, right? Now, I'm not advocating that you sign oral leases. I think you need, or you engage in oral leases. I think you should sign everything. It should always be in writing, right? But what the law says is it can be oral for less than a year and still be enforceable in a court of law. So that's the only exception to the statute of frauds. Everything else gotta be in writing to be enforceable. They're gonna ask you about this, so you're gonna have to remember the statute of frauds. Okay, so there are 5 essential elements to a valid contract. Turn the page to page 190. Down at the bottom on the left, gray box, highlight the 5 essential elements to a valid contract. These 5 essential elements: offer and acceptance, legal consideration, competent parties, legality of object, reality of consent. I'm going to walk you through all of these. First up is offer and acceptance. Okay, an offer leads to an acceptance. Okay, so he and Maria dated for, about a year. And at one point, did Maria come in, you're watching TV, she says, Angel, yes, I will marry you. Did she say that? Or did you ask her?
Ask.
You asked. So if she just walked in and said, yes, you would be like, are you off your meds? What's wrong with you, right?
That's going
So that's right, what's going on? So you had to ask, right? You had to be an offer. Would you marry me? And she then accepted, apparently, even though you don't know if you have to. I'm just going with what you've given me so far, all right? So what you had is Angel and Maria had a meeting of the minds. That's what they're going to call it on the test. Offer and acceptance or meeting of the minds. Now, we know in real life what happened is Angel met Maria's mind. She said, big boy, time to go. He said, oh, good. Okay, sometimes they'll call it mutual agreement, mutual assent, right? All right, now, when it comes to offer and acceptance, you gotta know who the players are. And so I say this because as we go forward in class, anytime you see somebody that, or a word that has an OR after it, that person is the giver of the thing. The EE person is the receiver of the thing. So, in an offer and acceptance, the offeror is the giver of the offer, and the offeree is the receiver of the offer, right? So, in our little scenario, who is the offeror? Who is the offeree? Between you two, who's the offeror? Who's the offeree? Who's the person giving the offer? Angel, the buyer. You are the offeree. He is going to make you an offer to buy your house. Yes?
Yes.
Okay. So in this instance, we start out with Angel being the offeror and Angie being the offeree. Now, you call up Bill, your broker, and say, Bill, me and Maria want to make an offer on this house. So again, he was taught by the Greek man. He has the paperwork. He's ready, right? So he sits down. Now, on most contracts, I think there's 11 or 12 different terms. But what we're going to deal with for my example is 6, okay? Just so we can kind of keep it easier. So Bill sits down and says, okay, she's asking $300,000. What do you want to offer? And Angel says, $270,000. Okay? How much earnest money do you want to put down? Angel says $1,000. When do you want to close? 120 days. Okay? Are you getting a loan? Yes. We're going to get a 90% loan to value, and we want no more than a 5% interest rate. And then they get to the property taxes, and Bill says, we're going to ask them to prorate at 110%. Okay? So these are the 6 terms that they're filling out the agreement with. Then you are going to sign, Maria is going to sign, right? So he wrote it up with specific terms. Then Bill's going to go back to he's going to take a check for $1,000 made out to my company, right? He's going to go back, he's going to scan it, he's going to send it over, he's going to call me and say, Art, I got an offer for 123 Main Street. I say, thanks, Bill, for the offer. I will present it to my client and get back to you. So he has written it up under specific terms and communicated the offer to me, who is her legal representative. Yes? Okay. Now, my client, the seller, has 3 options. She can accept the offer as given with all 6 terms. She can reject the offer outright. Or she can counter anywhere between 1 and 6 terms, meaning she can go back and say, I don't want this, I want this. Okay? So here's what you got to understand about this. If she counters as little as 1 term, just 1, okay, and I communicate that back to Bill, that you're countering any 1 term, it is actually a rejection of the original offer, and the original offer is dead. It no longer exists because she's rejected the offer as given. Okay? And what she's doing is she's saying, Angel, I'll take these 5, but I want to change this one. Now it's going to be your choice here in a minute what to do with this. You with me on this? Now, I'm telling you this specifically because usually there's a question on the test that says, Angie rejected the offer, or Angel submitted the offer and gave Angie 48 hours to respond. Angie responded in 2 hours and rejected one of the terms. Okay? Then it says Angie sleeps on it overnight and wakes up in the morning and says, you know what? I've reconsidered. I'll take the original offer. Can she take the original offer? Because it's dead. Exactly right. See, people in their head go, well, I have 48 hours. Now, if you don't answer for 48 hours, you're okay. But if you answered and rejected 1 term, You don't get the other 36 hours. It's dead. You with me? That's how they're going to try to trip you up when it comes to contracts. So I'm warning you now. Okay? Now we'll come back to our scenario here in 1 minute. Let's look at their scenario. So the seller, Angie's asking $450,000. You guys, you and Maria want to offer $420,000, right? So you're the offeror, Angie's the offeree, right? And you're offering $420,000. So you send it over. Angie has 3 options. She can accept, she can reject, or she can counter. Okay, Angie says, I want to counter. And I said, how much you want to counter for? She says $430,000. Now I need you to watch the screen on this. Okay, so I'm going to call up Bill and I'm going to counter. So watch what happens. Okay, so the buyer's offer is $420,000 and Angie wants to counter at $430,000. Did you see what just happened?
Mhm.
Okay. What that means is that the buyer is not always the offeror. When Angie counters, she says, I reject your offer of $420,000, but here's my offer of $430,000. Now you, the buyer, are the offeree. You now have the same option she had. You can accept it, you could reject it, or you could counter it. Okay, but what happened to Angel's original offer?
It's dead.
It's dead. As soon as she counters, as soon as I tell Bill, the original offer is dead. You with me on this? So let's talk about our little scenario. So we had 6 terms, right? So I sit with Angie and she says, Art, I don't want to sell it for $270,000. I want you to counter back at $290,000. I say $1,000 earnest money. He's not serious at $1,000. This guy's gonna put 10 grand. He's gonna put 10% down. That's like 28,000. We want $5 grand. Prove that he's serious. Okay. She says, well, I don't want to close in 120 days. I need to close in 60. Right. Now the loan to value 90%. We're okay with. The 5% interest rate we're okay with because that's what rates are right about now. Right. And then we get to the 6th item, which is the prorated taxes. I just say, nah, we're going to prorate it 100%. His broker's trying to make him a little extra money. So out of the 6 terms that we have, we agreed to 2, and we're going to counter on 4. With me? Now, I printed the contract out, or the offer out, when I went to her house. I don't do anything with that paperwork. What I do is I either call Bill or I send him an email. Bill, thank you so much for your offer. My client would like to counter at $290,000, $5,000 earnest money, 60-day close, and 100% tax proration. So Bill says, thank you. He goes and sees his client, Angel and Maria. So Angel's like, we don't want to pay $290,000. We'll pay $280,000. So you're going to counter at $280,000. We're okay with the $5,000 earnest money because we're going to put $28,000 down anyway. We'll give you $5,000 up front. We can't close in 60 days. We can close in 90 days. And we're okay with that 100% thing because that was you just trying to make us some extra money, right? So out of the 4 terms that we counter with, they accepted 2, but they're going to counter us back on 2, right? So Bill calls me up. Now, what happened to our offer back to him? Dead. So he says, we'll take those 2. We want to counter back at $280,000 and 90-day close. So I go and talk to her. She says, I don't want to sell for $280,000, $285,000 and 70-day close. I go back to Bill. Bill goes to you guys. Maria's like, we're not going to pay $285,000. Let's split the difference. We'll pay $282,500 and we'll close in 75 days. He communicates it back to me. I bring it to Angie, and Angie goes, I'm okay with that. So what I do in that moment is I take the original contract and I strike the 4 terms that we're going to change. I put in the final terms. I have Angie initial those, but I also have her sign the rest of the contract because you and Maria had already done this. You had already signed the offer, right? So I have you sign all the rest of it, initial all the rest, right? Then I take that and I scan it and I send it to Bill. Bill's got to print it out and he's got to get you guys to just initial the 4 changes, right? So they initial the 4 changes. He says, give me a check made out to Art's company for $5,000, right? And then Bill delivers it back to us. Okay? So in offer and acceptance, there's 3 steps. Offer, acceptance, and delivery of the acceptance. Because if she said to me, okay, I'm good with that, but we didn't tell you that we were good with it, did we accept it? No. You with me on this over there?
Mm-hmm.
Okay, so you have to have the 3 steps. Offer, acceptance, and delivery of the acceptance. They're going to try to trick you on this. I'm warning you. What they're going to do is they're going to give you a series of steps and say, at what point do you have a valid contract? And the point is, after you have offer, acceptance, and delivery of the acceptance. Yes?
Mm-hmm.
So that's number 1. The second thing you need to have a valid contract is consideration. Consideration is defined as something worthy of exchange. It must be specific, and it's good and or valuable to both parties. So what is the most typical form of consideration in real estate? What do people usually give you?
Money.
Earnest money, right? That is the most typical form of consideration. However, it is not the only form. Okay? So, you need to hear me on this. To have a valid contract, you must have consideration. But it doesn't have to be earnest money. Earnest money is a form of consideration, but there are other forms. Let's say that you and Marie are walking through her house, right? And you notice somebody in the house collects baseball cards. They've got signed baseball cards. They've got lucite boxes. But they got them all over the place, right? And you just happen to have a signed Ty Cobb rookie card. Ty Cobb was an old baseball player. It's so old that they hand drew in his face. That's how old it is. And you say, would you take this card as consideration for our contract? And she's like, oh, yeah, that'd be a great addition to my collection. Sure, yeah. Now me and Bill go, it's a piece of cardboard. Okay, but it's valuable to you. It's valuable to you. And so it can be used as consideration for a contract. Same thing. Do you guys remember Anna Nicole Smith? Did you ever hear about Anna Nicole Smith? You know who she was? She was a blonde woman, married an 83-year-old billionaire. Okay, she was on TV for a while. And so this chick signs a contract with the old man. And when the old man dies, the kids try to break the contract. But the contract was for love and affection. And the judge says, it's obvious she loved and affected that guy to death. Okay? So it didn't even have to be something physical. It just has to be something that's good and or valuable to both parties. Okay? So what you got to understand is that every valid contract must have consideration. It doesn't have to be earnest money. Okay? We're going to try to trick you on that. Next. To be a valid contract, it has to be for a legal purpose. So I call up my friend Angel and I say, Angel, I would like you to come and burn down my house so that I could collect the insurance money. When I collect the insurance money, I'll pay you 10 grand. Angel's like, I'm in. And he shakes my hand over the phone. So he comes over, burns down the house. I get the insurance money and I don't pay him. So he says, I'm taking you to court, fat boy. So, Your Honor, judge says, why are you here? Your Honor, this guy, we had a contract that I was to burn down his house and he was going to pay me, out of the insurance money he didn't pay me. So I'd like you to enforce the contract. Judge bangs the gavel, says, you didn't have a contract because it was not for a legal purpose. You're going to jail for arson and I'm going to jail for insurance fraud. Got it? It must be for a legal purpose. Now, you have to have competent parties. What does that mean? Well, one, you have to have the legal capacity to perform the contract. So she's selling you her house, right? She has to have the ability to convey the house. It's not like she could sell her neighbor Anita's house to you. I don't like Anita, so I'm going to sell her house. Well, you Angie doesn't have the ability to convey that house to you. So it is not a valid contract because she doesn't own it, right? You have to have the legal capacity. And you and Maria have to have the legal capacity to get the loan to be able to buy the house, right? You have to be legal age. What's legal age in the state of Illinois?
18.
18. And you have to have the mental capacity to understand what you're getting into, okay? Turns out, her ex, what do we call him, Bob? Bob isn't all that bright. So Bob says to her, hey, when you sell the house, I'm just going to stay in the basement. That guy, Angel and Maria, they're not going to know that I'm down there. They're never going to. No, Bob has to have the wherewithal to understand the ramification of selling the house is you got to get your happy ass out of the house. And we, the new owners, will be able to live there. Okay? All right. Now, I said every contract is one of these four things. Well, we've got three here. The first one is valid. A valid contract has all the essential elements and can be enforced. A void contract has no legal force or effect. So the agreement that I had with you to burn down my house, that's a void contract. It doesn't, no legal force because it was for an illegal purpose. An unenforceable contract is actually really valid but unenforceable. Okay? So that means it's unrecognizable by a court of law. So you go to Angie, you say, Angie, I'd like to buy your house. She says, I'd like to sell you my house for $250,000. You say, I accept. Now, you have an oral contract for real estate, right? It's valid because you can have an oral contract. But you go to closing and Angie doesn't show up. Because it's not in writing, you can't force her to sell you the house. It's unenforceable. Now, if you both show up on the day of closing, it's a valid contract, they'll close, okay? But valid but unenforceable, the most typical example on the state exam is an oral contract for real estate. I'll buy your house, I'll sell you my house, nothing's in writing. Valid but unenforceable. Yes? That leaves us only with one. Okay, and the one is called voidable. Voidable. So, on page 193, 1, 2, 3, 4, fifth paragraph down on 193. Okay, it says a voidable contract appears on the surface to be valid, but may be rescinded or disaffirmed by one or both parties based on some legal principle. Okay, so what does this mean? On the surface, it appears that the contract between you is valid. It looks like it's got all the essential elements. However, one of the parties has been or can be injured by going through with this contract. Now, they don't mean just physically injured. You could be emotionally injured, financially injured, reputationally injured. You could be physically injured, okay? But one of the parties could be injured by going through with it, okay? And so what the law allows is for that person to be able to void the contract, thereby getting their earnest money back or whatever they've put up, right? So what could injure someone? Here's what I want you to do. To the left of voidable, write these 5 words down. Minor, M-I-N-O-R. Drunk, you know how to spell that one. Fraud. Duress, D-U-R-E-S-S. And error, E-R-R-O-R, error. If you see those words, any of those 5 words, in a question, you immediately look for voidable as your answer. Okay? So I'm going to give you 3 examples for this so you remember this. All right? Number 1, let's say we had some, 22-year-old here, call her Sally, was going to sell her apartment, right, or sell her condo. And in the door walks 17-year-old Justin Bieber. And Sally's like, Justin Bieber, oh my God, Justin Bieber. And she sells the apartment condo to Justin Bieber. Now, in that transaction, who's the adult?
So,
Sally, right? So what that means is because Justin Bieber was 17 years old at the time that he signed the contract, that he could, at any point up to closing, void it and say, you know what, change my mind, you got to give me my money back. And she would have to give him his money back. Could she turn to him and say, you know what, I've decided I'm more of a New Kids on the Block person. I don't want to sell it to you. Can she decide she doesn't want to sell it to him?
No.
Because
she's not a minor. So,
that's right, she's the adult. Got it? So Justin Bieber has the potential to be hurt because he was a minor. He can get out of it. That's number one. Number two, Angel is downtown with me at my Madison location. We break for lunch. We go upstairs because it's in a lower level. We go upstairs, street level. Angel's walking down the street, you know, the sidewalk, right? And if you've ever been on a city street, you know, we know that the bus drivers were taught to drive by kamikaze drivers, right? These guys are like going 100 miles an hour, right? So I see Angel staring at his phone and kind of doing this, kind of. I'm like, what's this guy doing? You know, because I'm going to get some lunch. And I see this guy doing this, and all of a sudden he makes an abrupt left off the side or towards off the sidewalk, and he's about to step into a street. And I see this bus barreling down. If he takes that step, you are going to be a bug on the windshield of that, a big bug on of that bus. So I run up behind him and I pull him back quickly. But I'm not quick enough because his hand goes up and the mirror hits his hand and throws his phone and breaks his phone. Okay? But he's like, oh my God, fat boy, you saved my life. And, well, all right. He goes, let's go drink, because he likes to go to the bar. So we go down the West End and we start drinking. Okay? And after about an hour and a half, Angel says to me, do you have $1? And I say, yes. He says, give me the $1. So I pull out the $1 and he says, you saved my life, Art. What was the kind of car you wanted? She had a Jeep. What did you want? Escalade. He says, here are the keys to my Escalade as a thank you for saving my life. And I say, oh, okay, cool, thanks. And we drink some more and we Uber home. The next morning, he wakes up. What did I do? I gave that fat guy my Escalade. Could you get it back?
yeah.
I don't know. Okay,
Yeah.
There's no writing.
No, it doesn't have to be in writing.
You were drunk.
You were drunk,
Oh,
right?
that's wrong.
If you were drunk, you made a decision while you were drunk. It's not valid. It's a voidable contract, right? You say, I want my car back. Okay? But check this out. He gets up the next morning. He wakes up. The sun is shining. Birds are singing. He's snuggled in with Maria. The 2 or 3 or 7 kids he has that he doesn't know their names are all around. He's like, Daddy, we're so happy that you're alive. And he thinks to himself, how my family would be crushed today if I was killed. Oh, by the way, you're playing Pokemon Go. That's why you weren't paying attention. Okay? He thinks, I'm so happy that Art saved me. I'm so happy that I gave him my Escalade. Then he goes on about his day. So the deal is, it's your choice to void the contract or not.
You do it on the spot, or
No, I mean, you could, you sober up.
yeah, I mean once you're sober,
Yeah. I mean, you got to think about it and go, I really want the Escalade back, right?
not
Okay.
after a few days.
Well, again, at some point, somebody's going to say, how long did it take? I mean, if you were drinking for a week straight, the judge might go, when he sobered up, he asked for his car back, Or let's say you left and the Uber gets into a car accident and you're in a hospital. When you actually come to, you go, I want my Escalade back. They probably make me give you the Escalade back. Okay? That's the second one. The third one. So I've got a 3-flat that I'm selling. And Maria's buying. Now, this isn't me, the real estate broker. This is me, the owner. And I say, Maria, this property brings in $100,000 NOI, net operating income every year. I'll sell it to you for $50,000. Maria's like, hot damn, I'll buy that. You'll buy that too, won't you? Because it's a 200% return every year. So we signed a contract to sell Maria the house, right? 2 weeks before closing, Maria found out that I lied. As the owner, I lied. The house only gets $50,000 NOI, not $100,000. So I lied, which means I committed fraud, which means you could do what?
Walk away.
You could walk away. What are you going to do?
Not gonna buy it. I'm gonna cancel the
What are you
contract.
going to do? Hey, let me just get this. You're going to get 100% return on your money instead of 200% return, and you're going to walk away. So you paid $50,000 for the property, and it makes the same $50,000 every year. You're walking away. Where are you making 100% of your money?
Nowhere.
Okay, so just think about it. But here's the deal. It's her choice. It's not my choice. I can't say, I lied to you, so I'm canceling the contract. No. You're the person who has the potential to be injured because I committed fraud. You with me on this? So that's what you have to know about voidable. It is the person that has the potential to be harmed can void the contract. And here's the thing, it's not automatically void. Some people will say you committed fraud, it's automatically void. It is not. She could have just as easily said, I'll hang on to it because I'm still making 100% on my money. You would have done that. You would have said, I'm going to kick your ass, but I'm still going to buy the property because it's still 100%. I'm not making 100% anywhere. Right?
Mhm.
So it's not automatically void when somebody commits fraud. You with me on this?
Mhm.
So they're going to try to trip you up on voidable, void, valid, all those. Okay, so how do you actually discharge a contract? There's 4 ways. Here's my favorite. Performance. Okay, we've got the closing date scheduled for February 27th. Angel and Maria show up. You show up. Bob, nobody knows where he's at. Okay, and you guys sign all the paperwork. She makes her way to Malibu. You get the new house. Me and Bill, we get paid. Everybody's happy. We've discharged the contract. The second way to discharge a contract is by assignment. Who's heard of a wholesaler? Who knows what wholesalers are? You know what this is? Okay, so what a wholesaler does is they go and they find a property and they negotiate with the owner and they lock it up on a contract. Then they turn around and they try to assign the contract. They're selling the contract, right? You ever meet any of these guys? Yeah, it happens all the time. Okay, so what a wholesaler will do is they will say, I'll buy the property for $100,000. Property's worth $150,000, right? So they buy it for $100,000, cash 30 days. So the seller signs it. It says to Art Batuzzi and/or signs. So as soon as I have it signed, I go and I go out to my buyer group and say, I have a property worth $150,000. I'll sell you for $110,000. So Angel says, well, I'd like to buy that property for $110,000. How do I do it? I said, get a cashier's check for $10,000. Meet me at the Starbucks. So he meets me at the Starbucks. I show him the comps, can prove that the house is worth $150,000. He goes, well, how do I get it for $110,000? I have it under contract for $100,000. Sign that check over to me for $10,000. I'll assign over my contract. So you show up and you close with your $100,000. So you've got $110,000 all in, and the seller gets their $100,000, and I walk away with $10,000 as my assignment fee. So I'm discharging the contract from me by assigning it to Angel. With me? The third way is novation. Turn to page 194, second to last paragraph, highlight. Substitution of a new contract for an existing contract is called novation. Okay, just stop there. So in an assignment, we have the same contract, we just switch one party for the other, right? In novation, what you're doing is you're replacing one contract for another. Okay, so let's say Angel says, I can't move forward, I don't want to move forward, or I found my dream job, it's in New York. So he and Bill, instead of coming to us and saying, look, we want out, they could lose their $5,000. What they did is they went and found a new buyer, Sally, who will buy it under the same terms that Angel had. So they come to us and say, we want you to replace Angel's contract with Sally's. We don't care. We got the same terms, right? So that's novation. We replace one contract for the other. And then the final way to discharge a contract is to breach it. And we talked earlier about breaching is violating the terms of the contract. Now, you really can't stop somebody from breaching the contract. However, you do have what they call remedies. What if someone does breach the contract? What can you do? So we're going to look at it from the two sides, okay? We're going to look at it from the rights of the seller and the rights of the buyer, okay? So let's start with seller. So you go to the day of closing and Angel and Maria don't show up. So you have four things that you can do. Number one, you can rescind the agreement. When you rescind the agreement, everything goes back to the way it was before. You have to return their earnest money, but they have no interest in your property. It's like the contract never happened. When you rescind, it's as if the contract never existed. Her second option, in the contract, the $5,000 that you put up said, if the buyer defaults, the seller gets the $5,000 immediately as liquidated damages. Meaning you were supposed to close, you didn't close, it cost her money. She's been damaged. Well, the contract says she gets to get that earnest money immediately. The reason it's called liquid is because it's in our escrow account and we can simply write her a check. Okay? So liquidated damages is the monies that, per the terms of the contract, go to the party that was the victim of the default. The third option is she can sue you for additional damages. Okay? She, let's say, I know what it is you were buying for $282,500, right? You don't show up. You gave her $5,000 in earnest money. So it takes me 6 months to sell her house. We sell the house for $232,500. So she lost $50,000 because you defaulted. Now, she already got $5,000, so she can sue you for $45,000 as what they call compensatory damages to compensate her for the loss she suffered as a result of your default. Okay? So she can sue you for the difference. And then the last thing she could do is, instead of wanting your money, she takes you to court and sues you for specific performance. Specific performance says, I want you to perform the contract as agreed. Your Honor, that's what I want you to force them to do. Okay? So the judge calls you in and says, all right, Angel Maria, what happened? You said, Your Honor, the day before the closing, we lost our job. We felt terrible. We were embarrassed, so we didn't go. Judge says, you have a job right now. They said, no, we're both looking. Can the judge force you to close on a property you can't get a loan for? No. But if Angel says, well, I got this new job, we changed our mind. Judge says, too bad, so sad. You should have changed your mind well before, when you had the rights. You must close on this house for the agreed upon price. And then you can go resell it if you don't want to keep it. All right? Now, let's look at it from the buyer point of view. Angel and Maria are ready to go. You don't show up, Angie. What are your remedies? Well, number one, rescission. We want to rescind the agreement, give us our earnest money back, we're done. It's as if the contract didn't exist. Their second option is to get their earnest money back as liquidated damages. Give us our money back. The third option is you could sue her for compensatory damages. You know, you had movers, you had, the truck was all loaded, you were ready to go over there and she didn't show up, you didn't close. So you had to put stuff in storage, you had to go find a place to live, yada, yada, yada. So let's say it cost you an extra $15,000. You can sue her for $15,000 in compensatory damages. But the number one remedy for a buyer against a seller in default is specific performance. You sue her and take her to court and tell the judge you want her to perform as agreed, which is to sell you the house, to convey the house. So the judge says, Angie, what happened? Your Honor, the day before the closing, I lost my job. So I was embarrassed I didn't go. Judge goes, I got great news for you, Angie. She's like, yeah. He said, you're going to sell this guy the house. You won't need as much of a job because you're not going to have a mortgage. Or she says, I changed my mind. He says, too bad, so sad. You can't change your mind. It was too late, right? The only thing, I mean, I can't think of anything that would that would stop the judge from enforcing it, with the possible exception that Bob died. Okay, so if, let's say her and Bob were still tight, and Bob dies, like there's a death in the family. The reality is, the judge might say to you, dude, she's not in her right mind. She's stricken with grief, whatever. We might have to wait on this a little, right? But that's the only thing I can think of. There's no other reason that she would need to get out of this deal. Follow? So those are the remedies for a breach. Now let's talk about statute of limitations. In Illinois, an oral contract has a 5-year statute of limitations. A written contract has a 10-year statute of limitations. So what does this mean? When she signed the real property disclosure, right? And it said the basement didn't get any water. Remember that? 2 years later, the basement floods. And you realize you found documentation that she knew the basement would flood and she didn't tell you. Well, because you have it in writing that she said the basement didn't flood, you can sue her for up to 10 years after the closing. Okay? Other reasons people might terminate contracts: partial performance. Somebody partially performs and you decide we're done. Substantial performance, when you get tradesmen who will work and do almost everything, okay? And then you guys decide that we're gonna be done. You don't need to do any more. Impossibility of performance. When I was doing condos, the day that you filed your declaration, anybody who had a lease in the building has an automatic 120-day right of first refusal, okay? So let's say Angie comes in and says, I want to buy 1605. I say I can only sign a backup contract. I sign the backup contract with her, and on the 119th day, the person who lives in 1605 comes down and buys their property. I cannot perform because they have bought the property, where I can sell you something else, but I can't sell you that one. It's impossible. Mutual agreement. Now with this one, it's between the two of you. So Angel calls Angie up and says, hey, I got this dream job in New York, and I was just wondering, is there any way you would let me out of this? She goes, that's great, because I decided I want to sell. Let's just mutually agree. And they're like, yay, we'll return your earnest money. Everybody's happy except me and Bill, who aren't getting paid. Operation of law. If either one of you file bankruptcy, that could get you out of the agreement. And then rescission. It's as if it never happened. So when you rescind a contract, it's as if it never happened. Okay. Turn to page 196. Last paragraph. Okay. It says, highlight, in Illinois, the Illinois Supreme Court decision in the case of the Chicago Bar Association versus Quinlan and Tyson placed certain limitations on real estate licensees in drafting a contract for sale. The court ruled that licensees are authorized only to fill in blanks on printed form contracts that are customarily used in the real estate community. Okay, go to the top of the next page. First sentence, 197. All insertions and deletions must be at the direction of the principals based on the negotiation. Okay, so here's what happened. Sometime around 1960, the Chicago Bar Association, who do they represent?
Lawyers.
Yeah, I think they should represent bar owners. I think they're being shady by saying lawyers. But yes, they represent the lawyers. They woke up and they said, hey, those real estate people didn't go to law school. We went to law school. Why are they writing real estate contracts? Right? So he said they shouldn't be doing that. That's the unauthorized practice of law. So what they did is they went and found this real estate company, Quinlan and Tyson, and they sued them for the unauthorized practice of law. And this went to all the lower courts in Illinois and finally ended up in 1966 at the Illinois Supreme Court. And the Illinois Supreme Court heard the arguments, and our argument was simple. If we have to involve a lawyer every time we're going to write a contract, nothing's ever going to sell because lawyers take too damn long, right? So the court heard the argument and they made a decision. And what their decision was is it placed limitations on what we as licensees can do, okay? So it says that we are authorized to fill in the blanks on pre-printed contractual forms customarily used in our marketplace. That no blank spaces can be left to be filled in later, okay? We have the form. Now, what did the lawyers really care about? Money. They wanted to be paid because we were writing contracts, they weren't getting paid, right? So what they did is the associations and individual companies had lawyers write their contracts. And then they would leave blanks, okay? And we would fill in the blanks. So at the top of 197, get your pens out. At the top of 197 to the left, write down can do, and then put a line underneath it. Can do. Number one, fill in the blanks. Number two, strike language. And number three, put riders in R-I-D-E-R-S. Put riders in numerical order. So we can number them. If our contract has 5 riders, you can number them, right? Now, drop down just a little bit. Write down cannot do. There are 5 things we cannot do. Number 1, write contracts. Number 2, write riders. R-I-D. Number 3, write addendums. A-D-D-E-N-D-U-M-S. Addendums. Number 4, write amendments. And number 5, write general provisions. Write general provisions. So what's the theme here? What can't we do?
Write contracts.
We can't write any of that stuff.
Mhm.
So there's no language, no riders, no amendments. We can't write anything. I don't care what they say. The question very often is, can a real estate broker write a contract? And our answer is no. What can we do?
Fill it in.
Fill in the blanks. We could strike language. People will say, what's strike language? So let's say you're paying cash. I'd be able to put a big X through the mortgage contingency clause. You would initial it. That's striking language. We cannot write language. Now, some people are like, what about the chandelier? The chandelier is an item. You're not writing language. You're writing the chandelier, describing what they want, right? So you cannot write, I don't care how they put it to you, you cannot write contracts. You fill in the blanks, you strike, and you can put things in numerical order. And how soon after somebody signs it should you give them a copy?
Immediately.
Immediately, that's right. Good answer. Now, 197, 1, 2, 3, 4, 5, 6 1 down. Don't highlight yet, just listen. In Illinois, a licensee should not use any form titled offer to purchase if the form is intended to become a binding real estate contract. Illinois law requires that sales contracts indicate real estate sales contract at the top and bold. Highlight the next 2 sentences. Whatever the contract is called, it is an offer to purchase real estate as soon as it has been repaired, prepared, and signed by the purchaser. If the document is accepted and signed by the seller, it becomes a contract of sale. Okay, so when Angel and Maria are ready to write up their offer, they call Bill. Bill pulls off the form. At the top of the form, it says real estate sales contract, right? And they fill it all out and they sign it, okay? Then Bill takes what you guys signed, that package, right? What did they sign? At this point in the process, what did you sign? An offer. Maria says, well, no. It says contract right there. We signed the contract. No. Because has the other side accepted it? No. So it only becomes a contract after she signs it, regardless of what it says on the face of the document. With me? Okay, so the sales contract is used to bind the parties. It's considered the most important document because what it does is it's a blueprint for a deed. How do Angel and Maria want to take title to this property? You know, is it as husband and wife? Is it, you know, the various things I'm going to teach you tomorrow? How do they want to take title? And here's the thing, from being a guy that's done this for as long as I have and closing 7,000 properties, my number one pet peeve for my salespeople and my brokers is when you don't spell the person's name correctly. Or you sign the contract with Bill Johnson. Is Bill his legal name? What's his legal name? William. Bill Johnson doesn't exist legally, right? Or you get somebody who has 17 consonants and one vowel in their last name, right? And you get the vowel in the wrong spot. Does that guy exist? No. And salespeople used to say, what's the big deal, Art? So I go change it, so I fix it. I'm like, here's the big deal. Every time you give a buyer the potential to cancel because you made a mistake, they could take it. You know, let's say, you know, Angel's last name was misspelled, right? But he doesn't know that. The guy who signed it didn't realize it, right? But he goes home and his grandma says, what are you, crazy? You bought this house. You should have done it. So he's having second thoughts. Then he gets a call and says, oh, there was a little error on the paper. We just need to make a little change. And he's like, oh, it's not a valid contract. I'm out. I can't tell you how many times I've seen people do that. And it's all because the broker didn't have the common sense to say, let me see your driver's license. Because then they can put it into the paperwork exactly as it is. So there's a variety of parts of sales contracts that you're going to deal with. What did we say earlier? Whether it was today or yesterday, what do we say about when we get offers? What do we got to do? Right there on top.
Must be
Present all offers, right? Okay. And there's a clause called time is of the essence. In the contract, it says that the parties to this contract are adults, and they understand the time frames that they have agreed to in this contract are real time frames. They're not fuzzy time frames. They're not, ooh, let's see if we can hit those. They're not Maria saying, I don't feel like February, I feel like March. If you agreed to close on February 27th, that's the date. Follow? This next one cracks me up because I actually used to get this a lot. You can't believe how many stupid people there are in the world. So, contracts signed on a Sunday or holiday are legal. I be sitting in my office, get a call from the front desk. Hey, one of our buyers is here. They'd like to see you. I was the project manager. I'm like, okay. And so they come in and they say hi. I say hi. How can I help? He said, well, we were in the last week, a few days ago, and on Saturday or Sunday, and you know, I met with one of your people, and we signed some document. I'm like, oh yeah, you signed the contract. That's yeah. Or they go, well, no. Since we signed on Sunday, it's not a legal day, and so it's not a legal contract. I said, excuse me. They said it's not a legal contract because it wasn't signed on a legal day. I go, where are you from? And they go, Cicero. I'm like, no. What planet are you from? Because here on Earth, how many days we got? 7. Every day is legal. They're going, no. It's only Monday through Friday. Only Monday through Friday. And I'm like, no. What did you do with the money your mother gave you for law school? Because you didn't go. Okay? Every day is a legal day for you to sign a contract. Every minute of every day is a legal day, a legal minute for you to sign a contract, right? What are they talking about? Monday through Friday, what are they talking about?
Those are business days.
Business days.
Saturday,
Okay.
Sunday, and Monday are all considered one in the banking.
Well, but the point is they're business days,
Right.
yes? So the issue is this. Business days are only used, or any day, any reference today is only used to start the clock ticking. So if we agree Friday night, 8 p.m., okay, and you have a 10 business day right to get the house inspected, when's his first day?
Monday.
Monday. If you have a 10 calendar day, when's your first day?
Saturday.
Saturday. That's it. And people will be like, no. And I'm like, look, Perry Mason, you need to relax. Okay, why are you here? What's the issue? And usually it was somebody told them something, then they got afraid, and then somebody else said it's not illegal, so they thought so usually I was able to calm them down and work through whatever their issue was and keep the deal in play. But I love when they would walk in with that. I'm like, these people are stupid. Okay, earnest money deposits. We've talked about this a couple of different times, right? So on page 199, get your highlighters out, leave them out. So go to 1, 2, 3, fourth paragraph down, highlight. Sponsoring brokers who are holding earnest money deposits and sales and security deposits and leasing must establish special trust accounts, also called escrow accounts, for the deposit of funds entrusted to them in connection with real estate transactions. The drop to the next paragraph, last sentence. Escrow reconciliations must be completed within 10 days after receipt of the monthly bank statement and must be kept for a minimum of 5 years. Then drop to the last paragraph, first sentence. Sponsoring brokers are strictly prohibited from commingling, that is, mixing their own funds with funds in a special escrow account, except for the purpose of maintaining a minimum running balance required by the depository. All right, so earnest money is evidence of the buyer's intention. That's where it comes from. It's earnest. I'm being earnest in making this offer to you. So I'm putting up, or Angel's putting up $5,000 to show you that he's earnest about this, right? So the idea is it's meant to discourage default. And here's what I'll tell you. When I'm looking at offers for my clients, and I got one guy at 1,000, and I got one guy at 3,000, and I got a guy at 10 or 20,000, who do I think's more serious?
And play.
Yeah. So I always say to my clients, how serious are you? Because you got to let them know that you're serious. Now, if you're only putting 3.5% down, maybe you put all of it up. All right? Where that's how serious we are, right? We'll put all of our deposit, our all of it up front. Now, keep in mind, these can only be put in the 2 types of accounts, special trust and escrow, right? It's got to be in a federally insured bank. They're usually non-interest bearing. The company needs to maintain the records on these, right? And when do they have to be deposited? Who remembers the phrase? Earnest money must be deposited,
Right, 24 hours.
not 24 hours.
Upon acceptance of the
Well, that's the last part, but when is it?
one business day.
1 business day from acceptance, not receipt. 1 business day from acceptance of the contract. Okay, so some terminology here. Go to page 214. So we're going to skip that whole contract that's in the middle. That's an old one. But you can look at it if you want at some point, just not now. 214, equitable title. So when Angie accepts your offer for the house, she accepts the money, meaning the money comes to us. She is actually giving you an equitable interest in the property. She's giving you equitable title, which basically means you own nothing But what it means is that she can't go sell it to somebody else because she's agreed to sell it to you. Okay? So you have an equitable interest in that property. That's why when somebody wants to cancel, I don't let them cancel. I let them rescind. Because if they rescind, it's as if the contract never existed, so you never had equitable title to the property. With me? Next, Uniform Vendor and Purchaser Risk Act. What this does is real simple. The seller is obligated to deliver the property to the buyer in substantially the same condition as what the buyer bought it. Okay? So Angel goes in the night before with Bill and notices in the ceiling they're missing copper pipes. Did you buy it with copper pipes?
Yes.
Yeah. So she is required to deliver it to you with the copper pipes. So either she has somebody come in and fix the copper pipes, or she gives you an amount equal to what it would cost to replace those copper pipes as a credit at closing. Okay? So she's got to give it to you in substantially the same condition. Liquidated damages we already talked about. These are the dollars in the contract that, if you default, go to the seller, right? So the $5,000 that you put up, going to go to the seller. This last one they took out of the book, so I want you to write it down in the left-hand column. Parole evidence rule. Parole evidence rule. P-A-R-O-L. Parole. And what it means is what's in writing overrides what's said orally. What's in writing overrides what's said orally. So we've got about 2 weeks to close, and Angel and Maria are walking through the house doing some measuring, right? And Angie happens to be there. So Maria says, hey, Angie, I noticed in the garage that there's a lawnmower. Are you taking the lawnmower with you? And Angie's like, well, no, I'm moving to a condo. They mow the hallway for us. Would you be willing to leave the lawnmower? Angie's like, sure, I'll leave it for you. Okay? The night before the closing, Maria and Angel go in. Lawnmower's not there. She says, Maria says, I'm not closing. She promised us that lawnmower. Problem is, it wasn't in writing. So she can't stop the closing for something that wasn't in writing. With me? So what does that teach us?
Everything in writing.
Get everything in writing. Exactly right. Now, the next thing, contingency. So on page 214, about 2/3 of the way down, highlight contingencies. Additional conditions that must be satisfied before a sales contract is fully enforceable are called contingencies. Okay, so let's talk about the most common types of contingencies that are out there. First off, almost every real estate deal contract has an attorney review period. And so what it says, it's usually 5 days, 5 business days, and says the attorney can disapprove of this contract for any reason during the next 5 business days. And if he or she does, you have to return the earnest money because the contract is null and void. So that's the period of time I want Marie to think about it. Okay? She's in first position. She wants to think about it, right? The next contingency is the inspection contingency, or the home inspection. Usually this is a 10 business day right, and it runs concurrent with the attorney review. So it's not 5 plus 10, it's 5 of 10. So you have to have an inspection done if you're going to do an inspection within 10 business days. Okay? If you find something in the inspection that you don't like, you can bail on the deal and we will have to return your earnest money. The next contingency is probably the most important one. It is the mortgage contingency. We said in his offer that Angel and Maria were going to get a 90% loan to value at a 5% interest rate or less, right? So the whole deal is contingent upon them getting that deal, 90% at 5% or less, right? And if they are unable to get that, then we will call the contract null and void, and you will get your earnest money back because you can't get the loan, right? Now, here's what you got to be careful of. There's usually time frames associated with mortgage contingencies, 21 days, 30 days, right? And if your client is heading towards the end of it, I'm going to warn you now, you as the realtor have to be the driver on this, because the attorneys don't do anything unless they're told to do something, right? So if I see we've got 5 days left and I call and the lender's like, yeah, we haven't made a decision yet, I call the attorney and say, ask for an extension of another 5 days or a week. Because if we get to the 31st day without asking for an extension, your money is hard. Meaning if you don't get that mortgage, you're just going to lose the $5,000. So you as the realtor need to be you got to be paying attention. You need to be the driver on it. Next, house to sell. Angel comes to us and says, hey, Angie, I have a house to sell. I want to buy your house, but I want to make it contingent upon me selling my house. Now, if we had a lot more time for Angie, we might agree to that, but we don't. We got 60 days. So I say, Angie, as soon as we accept that offer and put it contingent, every other showing is going to drop like a rock. So we're not going to do that because we need to get you out of here in 60 days. But let's say she hasn't had any fish, 90, 120 days. If he shows up with an offer contingent upon him selling his house, as long as he's in line with price, I would say, we got a fish, let's take the fish. The only thing I would do differently is, or in addition, is I would have the attorney add what they call an escape clause. I call it a kick-out clause. It says, Angel, the seller will accept your contract contingent upon you selling your home. However, the seller's going to continue to market the property. And if we were to receive an offer that doesn't have the same contingencies, meaning it doesn't have a home to sell, we can give you notice that we've received another offer that we're considering. You have 72 hours to either remove your contingency, which means that we plan the closing, or to bail on the deal, we will give you your earnest money back. If he does nothing after 72 hours, the contract is null and void. We send you your earnest money back and we can take the other deal. With me? So that's an escape clause or a kick-out clause. And keep in mind, amendments and addendums. Addendums a little addition, amendments another page. We don't write any of that stuff. We either use pre-printed addendums or we have the lawyer do the language. Okay, next, an option contract. 215. To the right of option, what did I say option means?
Future.
Future, good. Write down future again. Just because Angie didn't remember it.
Nope.
Okay, so underneath option, highlight. An option is a contract by which an optionor, generally an owner, gives an optionee, generally a prospective purchaser or lessee, the right to buy or lease the owner's property at a fixed price within a certain period. The optionee pays a fee agreed on upon consideration for this option right. Then drop 2 paragraphs, highlight the first 7 words. The option agreement, which is a unilateral contract. Okay, so Angel comes to us and says, I want to buy your house. You're asking $300,000. I want to buy it for $300,000. The issue is this. A couple of years ago, I got in a car accident, and I am suing the people, and my court case is coming up here in the next 60 to 90 days. So what I want to do is I want to buy your house, but I can't buy it right this second. I mean, I can't close on it. So I want you to give me an option to buy your house in 120 days. So you will give her $5,000 today as an option fee, basically to take it off the market, okay? And you will give Angel an option that anytime in the next 120 days, he exercises that option, you're going to sell him the house for $282,500, okay? If we get to the 121st day and Angel hasn't exercised his option, you're free to put it back on the market. In either case, you keep the $5,000. Okay, because that was the option for you to take it off the market. All right. So in this situation, the optionor is the seller, the optionee is the borrower, right? And it is a legal contract. However, it's considered unilateral because only one guy, Angel, is obligated to perform. Meaning, if he wants to exercise his option, it's only him. She can't force you to exercise the option. With me? Turn the page. Land contract. Top of page 216. Highlight. A real estate sale can be made by land contract, also called a contract for deed, an installment contract, or articles of agreement for warranty deed. Under a typical land contract, the seller or vendor retains legal title. The buyer or vendee takes possession and gets equitable title to the property. Okay, so there's 5 different names for this in the state of Illinois. It's installment contract, articles of agreement, contract for deed, installment land contract, articles of agreement. Here's the deal. They all mean the exact same thing. It means owner financing or seller financing. So let's say Angie owns this property outright. Like she has 5 different properties, but this one she owns outright. She has no mortgage on it, right? You come along and you say, Angie, I got in this car accident about 3 years ago, was unable to work, was unable to pay my bills, okay, and so my credit's for shit, right? So, but today I have a really good job and I've saved up $30,000. But I can't get a loan. So what I want to do is I want to give you the $30,000 and I want you, the seller, to give me a mortgage for $270,000 at 6%. So essentially, the owner becomes the bank. Okay? And you say to her, you know what? We'll do this for 5 years. We'll amortize it over 30 years. We'll do it for 5 years. And in 5 years, when my credit's back to being good, I will go to a bank and pay you off. Well, that's until Angie actually does the math. Because when Angie does the math, she knows that if she keeps this loan with you for 30 years, you will have paid her $900,000 for a $300,000 property. So if she needs her money today, or she needs her money sooner than later, then she might do this. If she needs it today, she's not going to do it. But if she doesn't need her money till later, she might do this for you so that she becomes the bank. And keep in mind, you, as the buyer, right, the seller retains the title. You will come up with a monthly payment for her, principal, interest, tax, and insurance. And every month you will pay her that. You're responsible for maintenance of the property, just like if you bought it from a bank, with a bank, right? Okay. The only difference is if you don't pay your mortgage, she can foreclose on it. And then she keeps every dime you've ever paid her, and she can go sell it to somebody else for $300,000. With me? So a land contract, it's not just land. It's sort of a misnomer. It's the property of the land. You're going to buy it from her over time. Got it?
I had a couple who did that
Yeah?
at the credit union. They came in and they had it for a while, like probably a year. So they came in and they were able to get a home equity loan to be able to purchase, to pay her off.
Really?
Mm-hmm. And then, so they did that, and then they took more money out of the property,
Mm-hmm.
and they bought the house next door. She also owned that, so she paid
Wow.
for cash. So now they have one mortgage for both properties, and now they're renting out the
That's cool.
other one. Yeah, they did a great.
So again, this is a great strategy. Do you realize this? That 40% of all properties in the United States are owned free and clear. Now, it doesn't sound like a big percentage, but when you consider how many actual properties that make up 100%, that's a lot of properties that people don't have mortgages on. Okay? Done. What'd you have last time? You had 1 through 10, right? All right, so I don't think there's math, but if there is, skip it. I'll look. Because I never remember. All right, so you do 1 through 10, you do 11 through 20. There's no math. Okay. Number one, a legally enforceable agreement under which two parties agree to do something for each other is called
B.
B, a valid contract. Two, a buyer approaches the seller and says, I'd like to buy your house. The seller says, sure. They agree on a price. What kind of contract is this?
None of these.
No,
I had said implied, but I went back and
it's not
looked.
implied. They agreed orally.
So it's unenforceable.
There you go. This is the most typical example of an unenforceable contract, an oral agreement for real estate. Three, a contract is said to be bilateral if
D.
all parties to the contract are bound to act. Four, during the period of time after real estate sales contract is signed but before title actually passes, the status of the contract is
D.
executory. Very good. Five, a man or woman sign a contract under which the man will convey his property to the woman. Nobody knows why. Okay. The man changes his mind. The woman sues for specific performance. What is the woman seeking in this lawsuit?
A.
A, conveyance of the property. Correct. Okay. Six, in a standard sales contract, several words were crossed out, others were inserted. To eliminate future controversy as to whether the changes were made before or after the contract was signed, the usual procedure is to do what?
D.
D, have both parties initial or sign in the margin along with date near each change. Correct. Okay. Seven, a buyer makes an offer on a seller's house. The seller accepts. Both parties sign the sales contract. At this point, the buyer has what type of title to the property?
D.
D, no. You said D as in donkey?
Correct.
Yeah, no.
A.
No.
I don't know.
Equitable. Equitable title. Because remember, when you signed the agreement, you gave him an interest in your property, right? Okay. 8, the sales contract says a man will purchase only if his wife approves the sale by the following Saturday. That's my life. His wife approval is
D.
a contingency. 9, which of these statements is true with respect to an earnest money deposit?
B.
B, it's evidence of the buyer's intention to carry out the terms of the contract and get paid. 80, a man or woman entered the real estate sales contract. Under the contract's terms, the man will pay the woman $500 a month for 10 years. The woman will continue to hold legal title to the property. The man will live on the property and pay all real estate taxes, insurance premiums, and regular upkeep costs. What kind of contract do these two people have?
A.
Land or installment. Very good. 11, under the statute of frauds, all contracts for sale of real estate must be
C.
in writing to be enforceable. Correct. 12, a buyer makes an offer in writing to purchase a house for $220,000, including its draperies, with the offer set to expire at Saturday at noon. The seller replies in writing on Thursday, accepting the $220,000 offer, but excluding the draperies. On Friday, while the buyer considers this counteroffer, the seller decides to accept the original offer, draperies included, and states that in writing. At this point, which of these statements is true?
C.
C, the buyer's not bound to buy. Why?
Because it's there, the contract's there.
The original offer is dead. Excellent. Good job. 3, a broker's found a buyer for a seller's home. The buyer is indicating in writing his willingness to buy the property for $1,000 less than the asking price and has deposited $5,000 in earnest money with the broker. The seller's out of town for the weekend, and the broker's been unable to inform him of the signed document. At this point, the buyer has signed
D.
an offer. Very good. The buyer and seller agree to purchase the house for $200,000. Contract states closing will occur on October 30, 2014, and contains a clause stating that time is of the essence. Which of these statements is true?
A or C.
Well, it's A.
I think it's A, yeah.
The reason it's not C is because they're saying that time is of the essence is not binding. It absolutely is binding. So it's A, if the specified April 30, 2014 closing date passes and no closing takes place, the contract may have been breached. 50, the buyer signs a contract allowing her to purchase property for $230,000 anytime in the next 3 months. The buyer pays the owner $5,000 at the time the contract signed. Which of these best describes this contract?
D.
Option. Very good. 6, in preparing a sales contract, an Illinois licensee may
A.
fill in the factual and business details in the blank spaces of a customary pre-printed form. 17, on Tuesday, the sponsored broker received $1,750 in earnest money from a buyer. The seller accepted the offer on Thursday. Where and when must the sponsoring broker deposit the buyer's money?
C.
C, in a special non-interest bearing trust account by the end of business Friday. Exactly right. So if you remember, 1 business day from acceptance, because other people will pick D because it's the next business day from receipt. But you did the right thing. 18, an Illinois broker does not need written consent of both parties to transaction 2.
C.
Fill in the blanks in a sales offer as directed by the buyer. Correct. 19, the unauthorized practice law was dealt with in which Illinois Supreme Court case?
D.
Chicago Bar versus Quinlan and Tyson. 20, which provision could legally be placed in an Illinois installment contract?
A.
Seller will retain legal title. Correct. Good job. All right, let's take a fast break while I get us set up for the next thing.